Thus says the Lord, set your house in order, for you shall die and not live. Law Bob Radio. Law Bob Radio. Welcome to Law Bob Radio with your host, San Jose estate planning attorney Bob Bergman. Law Bob Radio. Bob has been practicing law for over 30 years and is certified by the State Bar of California as a legal specialist in estate planning, trust, and probate law. Bob is here to help you set your house in order with valuable insights you can use today to prepare a better tomorrow for your loved ones. And now, your host for Law Bob Radio, attorney Bob Bergman.
Hi, welcome to Law Bob Radio with your host, estate planning attorney Bob Bergman. I'm in the second part of a three-part series on mistakes that you can make doing your estate plan, or ways you can mess up your estate plan. I've talked about a number of possible mistakes and things that I've seen over the years in my practice as an estate planning attorney, and I'm going to be talking about more in the two segments today. So let's jump right in there. Another mistake that I see people make, and actually it's made often by attorneys that are doing the drafting, is very sloppy drafting in a will or a trust, which sounds good on the surface, but may not actually reflect what you intend to do. For example, John had 3 children. His will said, I leave my estate to my surviving children. Now, it sounds good, but is that what John really meant? If his daughter had already died, did he really want his estate divided between his 2 other children? Or would he have wanted his deceased daughter's share to pass to her children, his grandchildren? And then the question is, will the law of the state where he lives at the time of his death provide some other meaning under the law? Careful drafting can avoid ambiguities like this. Now, another example, Janet had a will that left her estate equally, quote, to her descendants. At the time she drafted her will, she had 2 children, no grandchildren, but by the time she died, her son had 4 children and her daughter had no children. Under the law of her state, the term descendants included children, grandchildren, great-grandchildren, etc. Thus, by law, each descendant would get 1/6 of her estate. Do you think that's what Janet wanted? Or do you think she wanted her estate to go half to her son and half to her daughter? I think probably the latter. A properly drafted estate plan could have made this very, very clear. For instance, I leave my estate equally to my children, and if a child is then deceased, such deceased child's share shall pass to such deceased child's descendants per stirpes. Now, per stirpes is a very particular way of distributing property by inheritance. It's defined in the law. That's probably what both John and Janet meant when they did this kind of planning. Now, the next mistake is probably one of the biggest ones I see. And I see it especially here in the Bay Area, and especially in the Silicon Valley where I practice, where there's a lot of people that are highly educated and very, very good at what they do in their chosen profession. And they believe that because they do really well in their profession, they can do really well at everything that they put their hands to. Now, you know who I'm talking about. I might be talking to you right now. That's trying to do it yourself. Now, for example, a couple, John and Mary, they didn't want to pay an attorney like me to draft their estate plan, so they bought a living trust kit under which they or the survivor would serve as trustee. So they decided to modify the trust and change the language in the bypass trust, a special type of trust. It's typically created after one spouse dies to hold the property of the spouse that died first. And that trust said it allowed distributions to the surviving spouse for health, education, maintenance, and support. They decided that wasn't enough, so they added the words comfort and welfare to the language. It seemed harmless enough. Problem is, IRS regulations made it clear that this addition may result in the bypass trust being included in the surviving spouse's taxable estate. Now, that was exactly what the bypass trust was trying to avoid. On a large estate, that could end up costing the family hundreds of thousands of dollars in federal estate taxes, sometimes called the death tax. Now, your estate, whatever size it is, still represents big dollars to your spouse and your children. So you really want to use a competent estate planning attorney to make sure your estate plan and any changes are written correctly. Now, another mistake is failing to realize that wills and trusts often can always be changed by whoever made them. Now, a couple had been married for over 25 years. Each of them had 2 children by a prior marriage. We call this a blended marriage. They wanted to provide for each other first and then leave things equally to all 4 children. Although their respective wills stated this intention, the survivor of them could always change the will to leave everything to his or her children. Or the survivor's will can't be found, perhaps destroyed, by one of all the survivor's children. And then all of the assets would pass to the survivor's children by intestate succession. The use of living trust can help protect children by a prior marriage. In addition, you can use a separate agreement where each spouse promises not to disinherit the children of the first to die. This agreement can actually give the children of the first spouse to die enforceable rights to inherit from the surviving spouse. Second, marriage planning is often complex and doesn't get the attention it usually deserves, even from a lot of attorneys that supposedly specialize in estate planning. Another mistake that I see a lot is relying on beneficiary designations to pass your property on. Now, beneficiary designations is basically where you have something like a retirement plan, a bank account, a brokerage account, and you put, on my death, pay this account to this person or these people. It doesn't handle contingencies very well at all, though. For example, if you name your son and daughter as the beneficiaries on your life insurance and your daughter dies before you, what happens to your daughter's share? Is it going to be paid to your son, or will it be paid to your daughter's children? It's really hard to say what's going to happen there. Most of us would like to think that it's going to go to the daughter's children, but most beneficiary forms I've seen say just the opposite. Typically says, we'll pay it to the surviving named beneficiaries. Now, by naming a living trust as the beneficiary of life insurance, or the beneficiary even of bank accounts and brokerage accounts, the trust could control exactly how the proceeds will be distributed and can include contingencies such as, what happens if my child has already died? Where is that going to go? Another problem I see is that people will actually try to leave property directly to a minor child or a minor grandchild. Now, here's the fact. No insurance company will knowingly pay $100,000 of life insurance to a 12-year-old. They will only pay it to a court-appointed guardian for the child, and that guardian may not be the person you would want to control that money. That guardian could very well be the former son-in-law or daughter-in-law of your child who actually divorced your child a number of years earlier. The cost of obtaining a court order for that guardianship can also be quite substantial. Now, for example, let's say you had a will or a beneficiary designation that says, give my deceased daughter's share to her children. If those children are minors, a guardian needs to be appointed by the probate court. In a guardianship, the money is required to be turned over to a minor once he or she reaches 18 to 21 years of age, depending on the state they're living in at the time. Now, here in California, it's 18 years of age. Now, I think most people would agree that's probably one of the worst ages to turn over a significant amount of money to anyone. If you're talking about giving a large amount of money to an 18-year-old boy, and yes, I'll use the term 18-year-old boy, in my opinion, unless that 18-year-old is serving in the armed forces, that 18-year-old is still a child. Giving it to an 18-year-old boy, they're probably going to go out and buy a car right away. Probably not a certified pre-owned Toyota Corolla. It's likely going to be a sports car, maybe the most expensive sports car they can find, and it's probably going to be red too, just to add insult to injury. It's likely that by the time that child turns age 19, there's no money left of the inheritance. It's all been spent, and they can't afford the 5 figures that they need to pay for the insurance on that sports car being driven by that teenage driver. So, an inheritance left in trust for a minor beneficiary can not only indicate who's going to manage the funds and make distributions for educational expenses, health needs, things like that, but can also indicate the age at which the funds would be turned over to the beneficiary. Or, as I often recommend, it can be kept in a lifetime trust, so it can be used to take care of that beneficiary for their lifetime, which also provides, by the way, a lot of asset protection for the inheritance. Now, I recommend to my clients the minimum age they could consider turning property over to a child is 25 years of age. I say that because that's what I've seen over the years, about 35 years of practice, that seems to be reasonable. And also there's now medical evidence to back that up, that common sense is not fully developed in men and women until about age 25. So as long as you have an inheritance held in trust for that beneficiary, it can be protected from their bad spending habits, protected in the event they get a divorce, protected from their creditors, and can indicate who receives the inheritance when that person passes away. Because of that, we often recommend lifetime trusts, because also you could give that person the ability to decide where that inheritance goes when that child passes away, or whoever the beneficiary happens to be. Now, after the break, I'm going to be coming back and talking about several more mistakes that people actually make in setting up their estate plan or in their estate planning, ways you can mess up your plan. So after the break, we're going to come back and talk about some more things. So until we come back, this is Bob Bergman, estate planning attorney. We'll talk to you after the break.
For questions or comments, send email to lawbobradio@gmail.com. That's lawbobradio@gmail.com. Now back to Law Bob Radio with your host, San Jose estate planning attorney Bob Bergman.
Hi, welcome back. Estate planning attorney Bob Bergman here. Before the break, we talked about a lot of the ways you can mess up your estate plan. A lot of them had to do with sloppy drafting, trying to do it yourself, which I never recommend people do. Same reason that I don't try to work on my own car and fix that. I go to a specialist for that. And then also that wills can be changed and beneficiary designations can go awry, and property left to people who are underage, where they get it directly when they're too young, is probably not a good idea. Another mistake that people make is the failure to consider, if you have a taxable estate, and by that I mean an estate taxable estate, which right now would be over $5,430,000 here in 2015, it's the failure to consider who's going to pay the estate taxes when you make distributions between various people. For example, John drafted a will, decided to leave his multi-million-dollar home to his companion of many years, and everything else was going to go to John's children. But the problem was, the will said, as most wills do, that taxes and expenses will be paid out of what's called the residuary estate. That means the remaining distribution of his property. So on John's death, the estate taxes would be paid solely out of assets passing pursuant to the residuary clause of his will, which means out of his children's inheritance. Now, in this extreme example, the home was worth more than the estate tax exclusion of $5,430,000. In fact, it was a $7 million home. What happened was, the extra money, and I put extra in quotes because it's only what Congress seems to think is extra, the extra $1 million+ that home was worth, the estate tax on that, ended up being paid from the remaining property that was passed on to John's children. At $1 million, that would be $400,000 of estate tax. And since he was only leaving $2 million more to his children, they took a $400,000 hit from their inheritance, while his companion walked away with the $7 million home tax-free. I doubt that's what John would have wanted if he had considered who actually pays the estate tax. He might have wanted his companion to be responsible for the estate tax on her share and his children responsible for the taxes on what they were going to receive. So, phrases like pay all taxes out of the residuary estate sound good, may not be what you want unless you fully understand what they mean. Now, in the trusts I usually draft, I typically provide that anyone receiving property outside of the trust pay their pro rata share of estate taxes. That means someone receiving on a retirement plan or even life insurance. But sometimes that's modified depending on what the client wants. It's important to talk about these issues when we're talking about specific gifts or property going to people. Now, another mistake closely related is the failure to consider the income tax aspects of the property you're leaving. Now, Marlene had her life insurance and her traditional IRA, and they were of equal value on the face. So she decided to name her son as the beneficiary in the life insurance and her daughter as the beneficiary on her IRA. The problem is the life insurance proceeds are income tax-free, but the IRA proceeds are generally income taxable unless it's a Roth IRA. So when the daughter took that money, she lost about 1/3 of the value of that IRA to income taxes. So that's another reason I discourage people from leaving specific assets to specific people. You might want to use a living trust to balance these things out. Another mistake is to gift highly appreciated assets ahead of time. And this kind of comes in with like the don't use a joint tenancy and put your kids on the title. I see a lot of people who are talking about giving their home to their kids before they die, maybe because they're terminally ill. They don't want it to go through probate. The problem is that when you do that, you give away to your children your acquisition cost for that property, sometimes called your cost basis, and that is what determines what they might owe as capital gains tax when they subsequently sell that property. The better approach is to put that property into a living trust and make sure your children can inherit 100% of the property when you die. They then get a new cost basis equal to the fair market value on the date that you die, which means they could sell that property shortly thereafter for its full value and pay no income tax. That is a big benefit, and it's something that people foul up or mess up all the time in their estate planning. Another mistake, and this is for those of you who might have charitable intent. A lot of my clients want to leave a portion of their estate to one or more charities. Some of them want to leave a dollar amount. Some of them want to leave a percentage of their estate. In any event, they have charitable intent. Now, here's an example where Mark, we'll call him Mark, wanted to leave $20,000 to his church upon his death and the rest to his children. So the problem was Mark's attorney was not really experienced in estate planning, but he drafted Mark's will for a very, very reasonable fee. It was almost free. And it said $20,000 to my church and the balance equally to my children. Mark's large IRA, which was designated to pass through to his children, passed to his children, and they had to pay income tax on that. Now here's the kicker. Had Mark funded the charitable gift to his church of $20,000 with money from his IRA, that would not have been subject to income tax because the gift to charity or the bequest to charity does not carry income tax with it. That would have been $20,000 less taxable income to his children. And that would have increased the amount that passed to them after income taxes by, say maybe $6,000 if you estimate a 30% rate for both federal and state income taxes. Charities don't care if they receive taxable income because they don't pay income taxes anyway. So Mark ended up saving a few dollars on the drafting side, but those few dollars he saved on the front end ended up costing his kids about $6,000 on the backside. $6,000 in income taxes that could have been completely avoided with proper planning. Now, another mistake that I see regularly is people will create a living trust, but then they neglect to actually go and transfer the property they own that should be transferred into the title or ownership of their trust. Now, for example, in my practice, I typically will do what's called funding. Funding is a legal terminology for retitling assets into a trust ownership. I will typically fund real estate that's here in California into a trust if my clients request me to do that. If they own real estate outside of the state of California, I will engage the services of outside legal counsel in that state to prepare the necessary paperwork so that it can then be turned over to me and I can supervise getting it signed and notarized and returned back so that it can be recorded. For other assets, such as bank accounts and brokerage accounts, I give detailed funding instructions on how to go about changing or retitling those assets into your trust name. Now, the problem is that a lot of people don't really follow through with that. The good news is that here in California, and especially in Santa Clara County where I practice, if someone fails to actually put those assets in there and they're worth more than $150,000 in total value, we can actually go to court and use the trust and other documents that are prepared to get the judge to sign an order turning it over to the trust after someone has died. But the problem is, if people, for example, take their house out of the trust after they put it in, maybe selling their house, buying a new one, taking title as joint tenants rather than in the name of the trust, or what is very common, refinancing their house and having the lender require them to actually take the property out of the trust to put the new loan on. Well, in situations like that, we often end up with a trust that is not funded with all the property that should be in there. And the problem is that you might end up in some counties actually having to take those assets, put them through the entire probate process using your will to get them turned over to your trust. Not the case in most of the counties here in the Bay Area, but it can be the case in some of the counties in Southern California and in the Central Valley. So, by not actually titling things into the ownership of a trust, if you have one, you're actually creating problems for the family later on, who may have to actually go to court to get those ending up in the trust. So the moral, if you have a living trust, be sure to fund it with your assets by changing record title or beneficiary designations as directed by your attorney. Now, we've covered a lot of territory in this show today. We still have one more show to do, and we're going to cover the final ways you can mess up your estate plan in that third part. What I want to encourage you is, if you've heard something in the first part or the second part that says, boy, I really need some assistance, please give me a call. I can be reached at 408-247-0444 or rpb@lawbob.com or through my website at lawbob.com. I look forward to sharing with you more things in the third part. But until then, this is Attorney Bob Bergman for Law Bob Radio. Goodbye.
You've been listening to Law Bob Radio with estate planning attorney Bob Bergman. Bob gives regular seminars on estate planning and is available to do estate planning presentations for churches and other community groups. For more information or to schedule a consultation, visit lawbob.com, lawbob.com, or call his office in San Jose, 408-247-0444. That's 408-247-0444.
Opinions expressed are for informational purposes only and should not be construed to be legal, financial, or tax advice. Seek appropriate legal advice regarding your particular situation. Attorney Bob Bergman does not offer any guarantees with regard to the outcome of your legal matter. Prior results in other cases do not guarantee a similar outcome in your case. All rights reserved.